Hey, good morning. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, May 14th. It's 9 a.m. We have a business agenda ahead of us. We will start with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have five commissioners present.
Good. Great to see everybody. Good morning. Hope everybody's enjoying the week. We start our agenda with commissioner comments. Does any commissioner have comments to inform the rest of us? Commissioner Mester.
Thank you. Just wanted the rest of the commissioners to know that Commissioner Cross and I were able to attend the Rule 511 hearing last night at Arapahoe County Fairgrounds on docket number 24008000192, which is the Crestone, State Harvard, Yale, and State Wetterhorn Handy's OGDPs. The meeting was well attended. I think we had 35 folks provide their thoughts and perspectives on the OGDP application, and appreciate hearings manager Thomas and Kirsten and everyone who were able to put that together for us. And thanks to Arapahoe County for offering us a space to have that meeting. I think I know the hearing was recorded. And so if anyone's interested in hearing the thoughts and voices of the community at that 511 hearing, it'll be available both in the docket and on the website. So thank you.
Thank you so much, Commissioner Messner, and thanks, Commissioner Cross, for leading that effort last night. The other commissioners will listen into the hearing ahead of any participation in an oil and gas development plan for those docketed matters. So thanks so much for that. Other commissioners with comments? Okay, seeing none, we move to consent agenda. These are adjudicatory items that don't generally have any real issues. Anyone have questions on consent? Seeing none, all those in favor of consent signify by saying aye.
Aye.
Any opposed? Motion carries. All right, next up is a new item. It has been docketed 250500081. This is a petition for rulemaking. We received this, I think, last week. So wanted to bring this to the attention of the commissioners. I see we have Kate Merlin with us, which is great. I've put together kind of some ideas about process. They're very consistent with how we processed previous ones. Let me read a little script on this, and then Ms. Merlin will have you respond, although I realize you've not heard me. So on May 6th, we received a petition for rulemaking from Wild Earth Guardians, 350 Colorado, Women from the Mountain, and I hope I've got that pronounced correctly, Physicians for Social Responsibility, Larimer Alliance, Sierra Club Colorado, Green Latinos, Earthworks, and the Black Parents United Foundation. The petition asks ECMC to conduct a rulemaking to require calculation of the social cost of carbon in all cumulative impacts analysis conducted under Commission rules, and to require additional specific quantifications of greenhouse gas emissions. For those who may be unfamiliar, a petition for rulemaking is an avenue through which any interested party may ask the Commission to conduct a rulemaking on a particular subject. The Administrative Procedures Act, that's the state law that governs how we do things, provides the Commission with discretion on what process we follow when considering a petition for rulemaking. To ensure consistency, I, as one commissioner, suggest that we follow the same procedures we've used for other recent petitions for rulemaking. And that is as follows. We instruct hearing staff to set this docket for an upcoming hearing. Prior to the hearing, we allow any interested members of the public to submit written statements to voice their positions on the petition. I'd suggest keeping those to 10 to 15 pages, double spaced, to let hearings manager Thomas figure that one out. To ensure that we hear from a diverse group of stakeholders, I would also recommend that staff notify all the parties involved in the cumulative impacts and enhanced systems and practices rulemaking of the opportunity to submit statements. And that's because we just recently finalized the cumulative impacts and enhanced systems rulemaking. This is asking for kind of edits to that. So having the same group that participated before makes sense to me, at least, or at least they don't have to, but it gives them the opportunity. At the hearing, the petitioners will have an opportunity, so that would be Ms. Merlin and her cohorts, to present the petition, and the commissioners could ask questions. So we would give an opportunity for sort of oral presentation to the petitioners. I do not suggest that we give an opportunity for oral presentation for any interested stakeholders. Instead, they would be bound to the written statements they provided. The commission can then consider the petition, the presentation from the petitioners, and any written statements that we receive. And then after deliberations, we may take it under advisement. The commission would vote on whether to grant the petition and initiate a formal rulemaking pursuant to Rule 529A. To my fellow commissioners, I would like to get your thoughts about this process. But maybe before we do that, if I could recognize Kate Merlin. I know we're asking you to kind of off the cuff think about this, but any thoughts about that process?
Thank you, Chair Robbins. I just wanted to make one note. Citizens for Healthy Community also joined as petitioners. I left
Okay.
them out of the caption by mistake, sorry, but they were
Got it.
signatories. This does sound like the procedure that was undertaken for the last petition for rulemaking in my memory. That sounds correct. And I have no objections to the process that you've laid out.
Okay, good. Well, thanks so much. And thanks for being with us. I know I caught you off guard kind of late in the morning before, and so really appreciate your presence. Commissioners, do you have questions of Kate Merlin, or do you have questions of the process or thoughts about the process? All right, seeing none, I guess I would move that we instruct hearing staff to docket this matter for hearing, consistent with the directions that I set out this morning. We have a second.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. Hearings Manager Thomas, can you work with Kate Merlin and sort of figure all this out consistent with what I said? It might be, I don't know, it's mid-May now. It might be like mid-June or early June or something like that. And that'll give time for parties to put together their written statements and all that stuff. Does that sound good?
Absolutely. We'll be in touch, Miss Merlin.
All right, great. Okay, that moves us to our next agenda matter, and that is to go into executive session to receive information, legal advice, and analysis as authorized by 246402(3)A, Roman numeral 2, regarding dockets 2411000287 and 2411000288. Assistant Attorney General Boudreau, take it away.
Thank you, Mr. Chair. Pursuant to the open meetings law, the commission is entitled to enter into executive session at this regular meeting to receive legal advice pursuant to Colorado Revised Statute Section 246402 3A2. The topics of the executive session were identified on the agenda, and they are to receive information, legal advice, and analysis regarding docket numbers 241100287 and 241100288. Mr. Chair, you are free to take a motion to enter executive session for the matters I just discussed.
So moved.
Second.
All those in favor signify by saying aye.
Aye. Aye.
Any opposed? Motion carries. Hearings Manager Thomas, where is our executive session link?
You should have a standing link on January 1st of
Okay, great.
2025.
Okay, so for everybody else, what we're going to do here is we're going to go into a different Zoom meeting that just comprises the commission and our attorney general. We will receive legal advice on the docketed matters as indicated by Assistant Attorney General Boudreau. Once we're done, we'll come back here and then we're actually going to take up those docketed matters. 30 minutes, 45, 20, I don't know, something like that. Stick around and we'll be back here shortly, and we appreciate you being with us. Okay, welcome back to the Colorado Energy and Carbon Management Commission. I will recognize Assistant Attorney General Benjamin Boudreau, relevant to coming out of executive session.
Thank you, Chairman Robbins. We are returning from executive session. During executive session, the commission received legal advice, regarding docket number 241100288 and number 241100287. During the session, the commission received legal advice and no decisions were made and no votes were taken. Chairman Robbins, you can take a motion to exit executive session.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. All right. Looking at my agenda, I believe next up is docket 241100287, a Rule 520 exception in a pooling docket. The petitioner is 5M Farm Company. And I believe the only matter for us to consider this morning is the consideration of requests for oral arguments on the dismissal. I'm fine with that. Does anybody have a problem with giving oral argument to the applicant and the petitioner at next week's hearing? Seeing none, I move we grant oral argument status and hear it next week.
Second.
Motion and a second. Seeing no discussion, all those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Applicant and petitioner, be ready to argue vociferously to us next week. Now we'll take up docket 241000253, an oil and gas development plan. This is Kira McGee. It's called the Fern OGDP. And I believe to get us started, we're going to hear from someone from Weld County. Good morning, Mr. Kavanaugh. Great to see you. Thanks for being with us.
No, thank you. Are you guys all able to hear me okay?
We can. I'm going to go fill up my coffee, but it's just in the same room. So I'll be listening, and we look forward to hearing from you.
No, thank you. Well, good morning, commissioners, and thank you for the opportunity to speak for a few minutes about the Weld County local process regarding the Kira McGee's Fern oil and gas development plan. The OJET department held a pre-application meeting for the Fern location, actually last year, August 28th, 2024. Attendees for the Fern included Kira McGee staff, ECMC, and also Weld County staff. The 1041 WOGLA application for the Fern was received on November 15th of 2024. The application was discussed with the applicant to clarify, enhance certain items, and the final application version was submitted November 21st of 2024. It was found to be compliant with applicable code, and we scheduled for a hearing. Weld County did not receive any applications for intervention for this location. The 1041 WOGLA hearing for the Fern was held on January 16th of this year, 2025, and was approved by Weld County's hearing officer at the same time. The final order for the Fern has been recorded at Weld County Clerk and Recorder on January 22nd of 2025, and was noticed to the Greeley Tribune on January 24th of 2025. Approval of the Kira McGee's application creates a vested property right pursuant to Article 68 of Title 24 CRS. The approved Weld County 1041 WOGA permit, Kerr-McGee's commitment to best management practices outlined in the application will protect the health, safety, security, and general welfare and present to future residents of the county, while also protecting both environment and wildlife. The approval permit is valid for 3 years with us. Construction must commence within that time frame, or an extension must be requested and approved, or the permit will just expire. Due to the fact that KMOG has completed the 1041 WOGA application and process, and the final order has been issued and recorded and legally published, Weld County has no additional concerns with the pending ECMC permit and would support the director's recommendation. I would also like to bring to your attention one error in the director's recommendation under the proposed development. In the third paragraph, the proposed location abuts the right-of-way and should be stated as County Road 26. That's all my comments that I have for today, but I do appreciate your time.
Thank you very much, Mr. Kavanaugh. Appreciate the perspective of Weld County with regard to its consideration of the permit, which also requires our consideration of the permit. So, any questions? All right, seeing none, I think we're going to see you a little bit later on the next one, so stick around. Ms. Wazelinski, good morning. Would you elevate all of your witnesses for the swearing-in ceremony?
Yes, Chair, thank you. It looks like we're still missing a few to be impaneled. If everyone could please turn your cameras on. And if we could look for Matt Wells, Justin Nelson, Anthony Lupica, Chad Brebis, Chris Honus, Corey Altenberg. It looks like we're missing those folks from our panel.
We are working on getting everyone elevated. If you haven't been elevated, please raise your hands. That might speed up the process.
Thank you.
All right, Mr. Bajura, let's go ahead and swear in the folks that are with us, and if other folks show up, we'll deal with them accordingly.
Thank you, Mr. Chairman. So I'll ask each of you to raise your hand, state your name, and swear to tell the truth. I'll go in the order that I see you all on my screen. Sorry, Mr. Crouch, do you have a question? You're muted.
Sorry, I was just raising my hand. People are gonna start.
Okay, sorry. We'll do you one at a time. And yeah, when I call your name, please raise your hand, state your name, and swear to tell the truth. And apologies for any mispronunciations. I'll start with Mr. Schlechtenmeyer.
Yes, Schlechtenmeyer, I promise to tell the truth.
Ms. Stetzel.
Paige Stetzel, I swear to tell the truth.
Mr. Crouch.
Tom Crouch, I swear to tell the truth.
Mr. Hess.
William Hess, I swear to tell the truth.
Mr. Griffin. I couldn't hear you, Mr. Griffin. I still can't hear you. Am I the only one who can't hear Mr. Griffin? Mr. Griffin, I'll come back to you. Maybe you can resolve your audio issues in the meantime. Mr. Holman.
Chris Holman, I swear to tell the truth.
Mr. Coleman.
Yeah, I'm having difficulties. My name is Matt Wells, but logged in under a different username. So I'm going to log out and log back in.
But do you swear to tell the truth?
Yes.
Thank you. Mr. Loudigan.
Nick Loundigan, I swear to tell the truth.
Mr. Honus.
Chris Honus, I swear to tell the truth.
I think I got everyone, but the list changed when someone left the panel. Did I miss anyone?
Ms. Wozzelinki?
I would say let's get moving. If any of our panelists were not sworn in and need to answer a question, maybe we can swear them in at that time.
Yep, sounds good.
Okay, well, we'll just get our PowerPoint up and running and then I'll get started. Okay, that looks great. Good morning, commissioners. My name's Kelsey Wozzelinki with Jost Energy Law. And with Jamie Jost, we represent Kerr McGee in the Fern OGDP before you today in docket 2410-00253. I would like to thank Director Kavanaugh for his comments today and Weld County for its participation through the WOGLA process and support of this OGDP. And we would also like to thank ECMC staff and the director for their efforts on this OGDP. Next slide. The Fern OGDP proposes one new oil and gas location, the Fern Pad, to develop 12 new horizontal wells within a proposed 1,760-acre drilling and spacing unit for the development of the Niobrara, Fort Hays, Codell, Carlisle, and Sharon Springs formations. The proposed Fern Pad is located outside of the mineral development area, as shown on this map, for a total proposed 1,775.75-acre OGDP. The Fern Pad is located in Weld County, and as Director Kavanaugh mentioned, the WOGLA was approved in January of 2025. The proposed location is sited outside of all sensitive receptors, and the OGDP triggers no Rule 304 ALA criteria. Specifically, there are no RBUs within 2,000 feet of the working pad surface. The proposed location is not within the boundaries of an identified DIC and is sited outside of HPH. There is one RBU approximately 2,018 feet from the Fern working pad surface, and Kerr McGee consulted with CDPHE and agrees to a robust set of BMPs to minimize and mitigate potential impacts, including Group 3 drilling muds, Tier 4 or equivalent engines during drilling and completions, renewable or grid power for all permanent powered production equipment on site, excluding external combustion sources, and the piping of oil and gas from the proposed location. In addition, although not required by ECMC rules, Kerr McGee has engaged with the RBU located approximately 2,018 feet from the working pad surface and secured informed consent from the tenant and owner of this RBU. Kerr McGee will describe its extensive community outreach during the presentation today. As part of the Fern OGDP, Kerr McGee has committed to plugging and reclaiming 25 wells within 1 year of all new wells turning onto production and decommissioning 7 facilities. Kerr McGee will describe the associated emissions reductions in the presentation today. And finally, Kerr McGee has complied with all notice requirements for the Fern OGDP. No formal petitions were filed, no public comments were received on the Form 2A, and Kerr McGee agrees to the 1 COA in the director recommendation regarding as-built survey of the working pad surface. And with that, I'll turn it over to Matt Wells with Kerr McGee to continue the presentation.
Yes, thank you, Ms. Wozzelinki. Good morning, Chairman and members of the Commission. My name is Matt Wells, and I'm a regulatory advisor at Kerr McGee Oil and Gas Onshore. Joining me today are several subject matter experts here to answer any questions you may have. Here is an overview of our permitting timeline for this project from the first pre-application meeting with Weld County, the ECMC, CDPHE, and CPW in August of 2024. The WOGLA hearing was held in January of 2025. Then in April 2025, we received the director's recommendation, and on today, our hearing. Noteworthy here is no public comments and no petitions were filed for the Fern OGDP. Next slide, please. Here you see our estimated phases of operation timeline for the Fern project. From pad construction starting in May of 2025, all the way through to interim reclamation, which we plan to be in January of 2027. Next slide, please. Kerr McGee has an executed surface use agreement in place and has received an approved 1041 WOGLA from Weld County. And in this slide, you can see the photos of the proposed Fern location. You can see that it is situated in the southeast corner of the surface owner's parcel. This is the preferred spot for the surface owner in this parcel. The proximate local government is the town of Platteville. They have no concerns with this proposal, and no Rule 304B2 criteria are met with this proposed location. Next slide, please. Here we're looking at the proposed location and the proximity to receptors. As you can see, there are 0 residential building units, 0 high occupancy building units. There are no schools, there are no daycares or designated outside activity areas within 2,000 feet of the working pad surface. The closest RBU, as stated before, is 2,018 feet to the north, and we have obtained signed informed consent from the surface owner and the tenant. Next slide, please. The proposed location is not within a high priority habitat nor floodplains. Burrowing owl surveys were performed and no owls were identified. Kerr-McGee will perform additional environmental surveys per CPW guidance prior to the start of construction. And if any issues are identified, we will consult with the CPW at that time. CPW has reviewed this proposal and they have no concerns. Next slide, please. Kerr-McGee is committed to plugging and abandoning 25 older wells and the associated 7 facilities with those 25 wells. This will remove approximately 15 oil tanks and 9 produced water tanks from this area. This will reclaim approximately 10.3 acres, and 8.5 of those acres are actually in high priority habitat. So when it's all said and done, Kerr-McGee will have reclaimed approximately 6.2 more acres than it will ultimately disturb with the Fern OGDP. Next slide, please. The haul route for Fern was very straightforward and simple, as it's situated next to Highway 85. Trucks only have to go about 1,000 feet to get from the Fern pad to Highway 85, and there are 0 RBUs along that path. Next slide, please. Kerr-McGee evaluates produced water management at a regional level, and produced water takeaway is vetted for every proposed location. Part of that scoping process is to evaluate if there are any third-party pipeline options in the area. Unfortunately for this project, there were none to tap into. The nearest capable SWD is about 7 miles to the southeast, and our evaluation, as you can see in the slide, the pipeline to get to that SWD would be fairly impactful, as 42 plus acres would be disturbed, and much of that path is through HPH, floodplains, and a DIC. And since the location is so close to Highway 85, it was decided that trucking produced water would be the least impactful to nearby receptors. Next slide, please. In respect to emissions, this graph shows the reported CO2e intensities for Kerr-McGee's new facilities that have been commenced after December 31st of 2022. The orange, green, and blue lines show the Regulation 7 new facility intensity requirements from the years 2023 to 2030. As you can see along the x-axis, the blue bar represents 7 Kerr-McGee facilities, again, that were commissioned after that December 31, 2022 date, and their respective levels of CO2 intensity, which are all significantly below the thresholds that have been set by the CDPHE. These state-of-the-art design facilities, coupled with best-in-class BMPs, has resulted in the lowest emission inventory of any oil and gas operator in the state, and helped us meet Regulation 7 targets several years early. Kerr-McGee's NOx intensity is actually 62% below CDPH Regulation 7 targets. And the other thing I'd like to highlight on this slide is the drilling rig power commitment. Kerr-McGee is always exploring the option for electrical rig for each of our proposed OGDPs, and Fern was no different. If the grid availability and the drilling rig availability and all the other factors line up, that will definitely be the case for the Fern wells. But at a bare minimum, Kerr-McGee commits to adhering to the AQCC use practice rules as outlined in Regulation 7, Part B6E1, which includes natural gas generators with battery storage systems, and or Tier 2 dual fuel engines, for example. And these ozone practices will be applied to year-round operations, not just during the ozone seasons between May and September. Next slide, please. Kerr-McGee has had the opportunity to consult with CDPHE on this project, first at that pre-application meeting in August of 2024, and then again for the official consultation in March of 2025. Kerr-McGee commits to 32 of the CDPHE's best management practices. I always like to highlight this graph as it shows the excellent work that the Kerr-McGee operations teams out in the fields are doing to either adjust, reschedule, or avoid certain activities during those ozone season to mitigate emissions. Next slide, please. Here you see just a few of the many best management practices that will be implemented to minimize operational impacts to receptors as much as possible. These include inspections, temporary emission control devices, drilling rig with sound reduction features, and a quiet completions fleet. Also to note, Kerr-McGee has committed to 340 linear feet of 32-foot high sound wall that will be on the south side of the working pad surface. Also, the grading and drainage plans were approved by the Weld County Planning Department and has been submitted as a part of this application. Next slide, please. The air monitoring plan for this OGDP has been approved by the CDPHE, and air monitoring summaries for this location will be posted to the Oxy stakeholder website monthly. Next slide. Over the past 4 years, using this approved air monitoring program, Kerr-McGee has collected thousands of air samples spanning all phases of oil and gas development. And all results, as shown on this graph on the left, are well below the CDPH health guidance value of 9 parts per billion for benzene. Next slide, please. Kerr-McGee has sent out all the required notices and will continue to post updates for this project on our stakeholder website. As said before, the nearest stakeholders are 2,018 feet away, and we have been in constant contact with them. We have had on-site meetings and continued conversations with them about our operations. And the surface owner and the tenant have no concerns and have both signed informed consent. Next slide, please. Here you can see a stakeholder engagement timeline. We have been very active in this area since September of 2024 and will continue to be very communicative with the stakeholders of this area. Next slide, please. Before I turn it back over to Ms. Wazelinski, I'd like to summarize just a few points. Like I said, no public comments were received. Weld County has approved this application. This site is located over 2,000 feet away from any critical receptors. And Kerr-McGee will adhere to the COA that staff requested to provide a Form 4 sundry showing the as-built working pad surface and the measured distance to that nearest RBU are in fact over 2,000 feet. And last, Kerr-McGee will plug and abandon 25 older wells and remove 7 facilities in the area, reclaiming 10.3 acres, which much of that are in HPH. That's all I have for you today. Thank you for your time, and I'll hand it over back to Ms. Wazelinski.
Thank you, Mr. Wells. This last slide shows the relief requested for the Fern OGDP. This does conclude our presentation. Kerr-McGee has a number of subject matter experts here on the hearing, so we can take our PowerPoint down. I'll have everyone here please turn your cameras on. And just a reminder, if anyone was not sworn in and answers a question, we can maybe do that at that time. Thank you.
Commissioners, the panel is open for questions. Despite the fact that you flooded us with witnesses, it does not appear we have very many questions. We move to deliberations. Does any commissioner desire to deliberate? Seeing no deliberations, I would move approval of the OGDP.
Second.
Motion and a second. Commissioner Oath.
Just a quick note that that the director's recommendation it did include the COA. So does that just want to make sure that we're including that?
My motion is amended to include relevant COAs as suggested by the director in the director's report. Does your second include that as well, Commissioner Cross?
It does.
Thank you, Commissioner Oath, for catching that. Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye.
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 Any opposed? Motion carries. I would note for the record that the fact that the commission did not ask questions is reflective of good work by staff, good work by the applicant to meet all of our protective regulations. We appreciate that. All right. That was Fern. We now move to the Wild Horse 2 OGDP, docket 240500110. Ms. Wazelinski, I believe this is yours as well.
It is. Thank you.
Do we have Jill Park to present to begin here? Mr. Boudreau, do you know? Hearings Manager Thomas.
We've just elevated Jill.
Okay, great. Good morning, Ms. Park.
Good morning. Hello, I'm Jill Park, one of the lead location assessment specialists for the Fundair Wild Horse 2 OGDP. For the record, excuse me, Verdad Resources LLC filed a petition due to the drilling and spacing unit of the Fundair Wild Horse 2 OGDP overlapping with Verdad's planned development in their proposed docket number 241100286 Verdad Jayhawk Fed 28332726 OGDP. The petition was resolved between Verdad Resources and Fundair Resources, resulting in the removal of the north half of Section 26, Township 10 North, Range 59 West from this Fundair OGDP. Fundair provided the relevant documents and information to update the Form 2A and the Form 2B to reflect this change in application lands. Location assessment specialists applied these changes to the forms. Due to this change in OGDP acreage, staff has proposed the following condition of approval to correct the OGDP acreage within the already approved Form 2C. The operator will provide an updated oil and gas development plan map that reflects the removal of the north half of Section 26, Township 10 North, Range 59 West to the OGDP mineral acreage via a Form 4 sundry to be applied to the OGDP ID number 488316 within 30 days of OGDP approval. This does not change the determination of the director's recommendation. Thank you.
Thank you, Ms. Park. Anyone with questions? Thanks for the clarification. If we get to approval motion stage, we'll make sure that COA is involved. With that, I believe we're now going to hear from Mr. Kavanaugh. Welcome back.
I'm back. Thank you again for your time today. And good morning still. Today, Weld County would like to discuss our process regarding the Fundair's Wild Horse 2 Oil and Gas Development Plan. The OJED had held the pre-application meeting for Wild Horse 2 location on May 10th of 2023. Attendees for the Wild Horse 2 included Fundair's staff and their consultants, Miracle Energy Consulting, RPG Resources, and Just Law Energy, Weld County staff, ECMC, CPW, the BLM, and also the CDPHE. The 1041 application for the Wild Horse 2 was received on March 1st of 2024. The application was discussed with the applicant to clarify and enhance certain items, and the final application version was submitted on the April 30th of 2024. It was found to be compliant with our applicable code here at Weld County and was scheduled for hearing. Weld County did not receive any applications for interventions for this location. The 1041 Weld hearing for the Wild Horse 2 was held on June 20th of 2024 and was approved by the Weld County's hearing officer at that time. The final order for the Wild Horse 2 has been recorded within Weld County Clerk and Recorder and was noticed to the Greeley Tribune on July 19th of 2024. Approval of Fundair's application creates a vested property right under Article 68 of Title 24 CRS. The approved Weld County 1041 WOGLA and Fundair's commitment to best management practice outlined in the application will protect the health, safety, security, and general welfare and present to future residents of Weld County, while also protecting both the environment and the wildlife. The approved permit is valid for 3 years. With Weld County, construction must commence within that time frame, or an extension must be requested or approved, or the permit will expire. Due to the fact that Fundair has completed the 1041 WOGLA application process and the final order has been issued, recorded, and legally published in Weld County, there's really no additional concerns with the pending ECMC permit, and we would recommend approval.
Thank you very much. Questions from Commission? All right. Seeing no questions, I believe you're on the hook for one more today. I hope everybody gets stuff done between OGDPs.
Thank you.
All right. Ms. Wazelinki, we will continue with the swearing in of the witnesses ceremonies.
Thank you,
I
Chair.
assume these are new folks.
Yes, they are. We've got a few witnesses. They are all here. If everyone could please turn your cameras on. They are ready to be sworn in.
Thank you. I'll ask each of you to raise your hand, state your name, and swear to tell the truth. Ms. Smith.
My name is Sydney Smith, and I swear to tell the truth.
Mr. Schultz.
My name is Joe Schultz, and I swear to tell the truth.
Mr. Brown.
My name is Brian Brown. I swear to tell the truth.
And that's all I see. Did I miss any, Ms. Wasilewski?
Yeah, there's a Mr. Stone and a Ms. Pfister.
Mr. Stone.
My name is Teal Stone, and I swear to tell the truth.
Mr. Pfister.
My name is Miracle Pfister, and I swear to tell the truth.
Thank you.
Thank you. All right. Chair, if with your permission, we've got a PowerPoint we can start sharing and we'll get started.
So permitted.
Wonderful. That looks great. Okay, well, good morning again, commissioners. My name is Kelsey Wazelinki with Jost Energy Law, and with Jamie Jost, we represent Fundair Resources Operating LLC in the Wild Horse 2 OGDP before you today in docket 2405-00110. We would like to thank Weld County for its support and participation in the WOGLA process, and Director Kavanaugh for his comments this morning, and also Ms. Park for her clarifications regarding the resolved petition and the COA for the OGDP map. And finally, we'd like to thank ECMC staff and the director for their efforts on this OGDP. Next slide. This OGDP requests that the Commission establish an approximate 1,601.36 acre OGDP for the development of 9 new horizontal wells in the Niobrara, Fort Hays, Codell, and Carlisle formations. The OGDP includes 1 amended expanded Form 2A for the Wild Horse 2 pad for the development of 9 new horizontal wells and 1 existing horizontal well for a total of 10 wells on the amended location. The OGDP also contains 2 spacing requests: to amend an approximate 641.36 acre DSU number 1 for section 2, and to amend an approximate 960 acre DSU number 2 for the south half of 26 and all of 35 to reduce setbacks and authorize the development of the Niobrara, Fort Hays, Codell, and Carlisle formations. I do want to briefly note that the mineral development area was amended following the resolution of a petition filed to the OGDP in December. The amendment removed the north half of section 26. After consultation with ECMC hearing staff, it was determined that the removal of lands did not require a new notice to interested parties. I would like to note that the north half of 26 is proposed to be developed by Verdad Resources LLC in an OGDP filed and awaiting hearing before the Commission. As stated by Director Kavanaugh, the proposed location is in Weld County, and the 1041 WOGLA permit was approved in June of 2024. There are no Rule 304B ALA criteria associated with the Wild Horse 2 location. The location is more than 1 mile from all RBUs, HOBUs, schools, childcare centers, and DIC boundaries, and is sited outside of HPH. There is Mule Deer HPH located approximately 190 feet west of the oil and gas location, and Fundair agrees to the COA listed in the director recommendation that states, if the operator uses ambient noise monitoring to increase the allowable noise level at the location per Rule 423D, the operator will obtain an approved Form 4 sundry notice with an updated noise mitigation plan that includes the ambient noise monitoring results prior to commencement of new construction. And I would also note that Fundair does agree to the COA clarified by Ms. Park this morning regarding the OGDP map. As part of the Wild Horse 2 OGDP, Fundair has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, including developing the 9 proposed wells in a single occupation with oil, gas, and produced water takeaway, plans to electrify the facility based on power capacity, a quiet frac completion feat, several light BMPs to minimize impacts to wildlife, and migratory bird nesting surveys based on operations timing and consultation with CPW if active nests are observed. And finally, Fundair has complied with all notice requirements for the Wild Horse 2 OGDP. One filed petition was resolved, and that petition has been withdrawn, and no public comments were received on the Form 2A. I'll now turn it over to Sydney Smith with Fundair to continue the presentation. Sydney, you're still on mute.
Thank you, Kelsey. My name is Sydney Smith, and I'm the Director of EHS&R for Fundair. We're excited to present the Wild Horse 02 OGDP to you today. This slide shows the topics that I will address in the presentation today. Next slide, please. This is the second OGDP that Fundair has presented to the Commission, so I won't spend too much time on introductions, but do want to highlight our team of subject matter experts on our panel today, and we welcome any questions you have following our presentation. This slide provides an overview of the amended, expanded Wild Horse 02 location, which has been constructed and currently has 1 producing well on the location. Fundair is requesting to amend and expand this location to accommodate 9 new horizontal wells. We have an executed SUA with the landowner, and the 1041 WOGWA permit was approved in June of 2024. This location does not trigger any ALA criteria and is specifically sited outside of high priority habitat, more than 1 mile from all other sensitive receptors, including RBUs, and is over 1 mile from the nearest DIC boundary. Next slide. This slide shows the timeline for this OGDP. Notably, we began the pre-app consultation process with Weld County 1 year prior to filing, and we have had an on-site consultation with CPW in August of 2023. As Kelsey mentioned, we did amend the mineral development area of this OGDP in April of this year, which resolved a petition we received on the OGDP. Aside from this one resolved petition, no public comments were submitted on the Form 2A and no other petitions were filed. This OGDP contains a spacing application, which is summarized on this slide and supported by land, regulatory, geology, and engineering testimony. Fundair proposes to develop the Wild Horse 02 pad in 2 amended DSUs for Section 2 and for the south half of Section 26 in all of 35. The minerals underlying the DSU are owned 100% in fee. As I mentioned, the amended expanded Wild Horse 02 location is sited outside of high priority habitat. As you can see on this map, the mule deer severe winter range and mule deer winter concentration area high priority habitat are located just west of the location. Use of an existing disturbance located adjacent to County Road 110 will avoid and minimize any potential impacts to the wildlife. In addition, the haul route for this OGDP is outside of high priority habitat, further reducing impacts. I did want to highlight the following BMP regarding construction or other earth moving activities within the migratory bird breeding season. If such activities occur, Fundair agrees to conduct migratory bird nesting surveys prior to the start of construction. So should any nest be identified at the time, Fundair will consult with CPW and implement appropriate BMPs as needed. Next slide. These next 2 slides outline how the proposed operations avoid, minimize, and mitigate adverse impacts. Starting with drilling and completion commitments, we will utilize Tier 2 dual fuel engines for drilling, and we will comply with CDPHE NOx intensity requirements. Fundair will utilize EPA certified Tier 4 engines during the hydraulic fracturing process, Group 3 drilling mud, and a quiet frac fleet. All freshwater delivery will be via lay flat line to reduce truck traffic, and we will conduct air monitoring at the well pad for at least 10 days prior to the start of drilling, during drilling operations and pre-production operations, and for at least 6 months after the proposed wells are completed and producing. For production, all oil, gas, and produced water will be connected to pipe infrastructure. In addition, the new facility will be tankless, and once the new wells are on production, the existing tanks will be removed. We plan to utilize line power to operate the production facility equipment. Hydrocarbon liquids will remain in a closed loop system, reducing emissions and odor. And finally, all lighting will be on the timer and motion sensors to minimize light usage only during scheduled activities on site. This slide shows the basis of operation for this location. We plan to drill the Wild Horse O2 pad in one occupation with construction starting in Q4 of 2025, drilling in Q1 of 2026, and completions in Q2 of 2026. I will now turn the presentation back over to Kelsey to conclude.
Thank you, Sydney. The Wild Horse 2 OGDP will protect and minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources, and will protect against adverse environmental impacts on any air, water, soil, and biological resources. The OGDP utilizes the amended expanded Wild Horse 2 location to minimize impacts and avoid sensitive receptors. Fundair is committed to the use of oil, gas, and produced water takeaway. The 1041 WOGLA permit has been approved by Weld County, creating a vested property right. No comments were submitted on the Form 2A, and again, one petition was resolved. And finally, the director recommends approval of the OGDP. This slide shows the relief requested for the Wild Horse 2 OGDP. We respectfully request approval of the OGDP. We do have a few subject matter experts here at the hearing who are available for your questions. So this does conclude our presentation, and thank you very much.
Thank you very much. Commissioners, the panel is open for questions. Commissioner Messner.
Thank you for the presentation. Thank you for the information. I did have a couple of questions as far as the amended DSU with and the resolution with Verdad. Did that end up reducing the overall number of wells associated with the application?
Thank you, Commissioner Mesner. I'm happy to answer that question. It did not. It only removed subsurface spacing lands from the application.
And so no need to make any modifications to the Form 2B or anything like that because the proposed operations are the same. It's just changing the spacing. Is that right?
Correct.
Okay. And then regarding your plan to electrify the production equipment, in your Form 2B, what did you anticipate when you developed the data for that? Was that with an electrified production facility or was that without an electrified production facility?
Our Form 2B does account for an electrified facility.
Okay. And so should you not be able to electrify, because I haven't heard a firm commitment to that, there would have to be a modification to your Form 2B.
That is correct.
Okay.
Yeah.
Those are the only questions that I have.
Other questions from the commission to the panel? Commissioner Ackerman?
Thank you, and thank you for the presentation. And I wanted to say, although you're outside of high priority habitat, I wanted to thank you for noting potential impacts to nearby high priority habitat and addressing those through the noise level BMP that you agreed upon with staff. I appreciate that over and above work. Just a couple of questions. The first one is associated with the converting of the existing well into tankless. And I noted that that's just something that you committed to evaluating. And I wondered if you could just expand on that a little bit. What will that evaluation detail? What would restrict that transition? And why not just make a definitive statement that you would transition that well into the tankless mode as well?
We will commit to doing it. I think we did outline in this presentation that we would definitely commit to converting that pad to tankless.
Thanks. I appreciate that. I must have missed that, so I appreciate that clarification. Also wanted to clarify on the drill rig type that you're planning on using. I saw Tier 2 dual fuel, and is that, just to drill a little further, no pun intended, sorry, is that a natural gas primary with a Tier 2 diesel supplement? Is it battery and engine management? Can you clarify exactly what you mean by the Tier 2 dual fuel.
Yeah, I will probably kick this to Brian Brown to kind of chime in on the specific rig type, but I do know that like at this stage, because we do not have an active drill rig going, we can't speak to the exact rig that we'll have, but Brian can probably speak a little bit better to the specifics of which one that would be if it were to go that route.
Yeah, it would be battery backup and it would be natural gas primary would be the goal there.
Thank you. I appreciate that clarification. That's all I have, Mr. Chair. Thanks.
Other questions for the panel? Seeing none, we move to deliberations. Does anyone desire to initiate deliberations? Commissioner Messer?
Thanks. This is an approvable application. I appreciate the considerations from a siting standpoint, keeping it away from sensitive receptors and high priority habitat. And the resolution with the conflict with Verdad, I think, is helpful too. I did want to make sure though that there's a condition of approval on the application that should they not be able to achieve electrification of the production equipment, that they submit a Form 4 sundry that revises their Form 2B so that we ensure that the data is accurate on that. So otherwise, I would recommend that we have them redo the Form 2B now, anticipating not having that production equipment electrified so that we have the other way around. But I think that they're anticipating the electrification of production equipment. I believe that they intend to do that. And so should they not be able to, I think it's important that that information be accurate.
Ms. Wozlinski, are you comfortable with that?
Yes, and Commissioner Mesner, the intent is to electrify, and Fundair agrees to amend the Form 2B if, for some reason, that's not possible.
Others with deliberative thoughts? Mr. Messer, was that a motion? Do you want to make a motion?
Yeah, I'll make a motion to approve the application with the commitment that they modify their Form 2B should they not be able to electrify the production equipment. And I can't remember if there's another condition of approval that
There was from Ms. Park concerning the modification of the removal of minerals.
So that one as well.
All right, a motion with 2 COAs. AAG Boudreau, you're visualized, which means you probably got something to say.
I believe there's another COA in the director's recommendation regarding noise levels.
So I'll modify my motion to include the condition of approval that I had mentioned associated with the Form 2B and electrified production equipment, the condition of approval that Ms. Park had indicated in her testimony today, and the condition of approval that's associated with the director's recommendation around noise.
Second.
Motion and a second. Further discussion on the motion? All those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Thank you, staff, for the good work getting us here. Thanks, Ms. Wozlinski, for the presentation with your panel. It's 10:53. Let's take a short break before we return to our last item. Let's return at 11, and then we'll take up the last OGDP. All right, welcome back. Colorado Energy and Carbon Management Commission, docket 241100288. MDS Energy Development is the applicant. It is petitioned by Incline Energy LLC. It's the Castor 29 OGDP. And I believe to get started, the commission needs to consider a challenge to the hearing officer order dismissing the petition of Incline 2 LLC. Ms. Jost, I see you're present on behalf of the applicant, is that right?
Yes, Chair. I'm representing MDS Energy Development LLC.
Sorry, but who's the lawyer representing Incline?
It'd be Mr. Cody Burke.
We've just elevated Mr. Burke.
Okay, let's bring Mr. Burke to the fore.
Morning.
Do you want to present yourself to the commission? Good to see you.
Good to see you. Cody Burke on behalf of Incline Energy 2 LLC, and joined by 8 other working interest owners in the unit.
Okay, so what we're going to do is we're going to give each side 5 minutes to argue the petition or the dismissal of the petition. Mr. Burke, I believe we'll hear from you first. If you want to reserve a minute or two for rebuttal, you can do that. Hearings Manager Thomas, can you keep track of time for us?
Yes.
Okay, Mr. Burke, you're recognized.
Commissioners, thank you for your time this morning, considering Incline Energy's appeal from Hearing Officer Thomas's decision to grant MDS's motion to dismiss Incline's petition, objecting to approval of MDS's proposed Castor 29 OGDP. My client is Incline Energy 2 LLC, which is the largest working interest owner in the Castor 29 OGDP and spacing unit proposed by MDS. Our petition to approving MDS's OGDP is joined by 9 other working interest owners in the proposed OGDP. Together, the group of petitioners own 48% or nearly half of the working interest in the application lands. And based on our records, MDS only owns about 22% of the application lands. Incline asks that the commission, following this argument, overturn the hearing officer's decision to grant MDS's motion to dismiss and approve the petition to proceed to a hearing. The hearing officer's order essentially states that a petition challenging the ownership threshold is not ripe for determination until the pooling stage, which is after the OGDP is approved. That was the position presented by MDS and approved by the hearing officer. We think that is an error for a variety of reasons. I know you have our briefing on these issues, so we won't reiterate all of them, but I want to focus on 2 of the main issues. First, allowing a minority interest operator to obtain control of a unit with less than a quarter of the acreage is against the intent of the legislature of adding the 45% threshold. The time to object to granting the ability to operate should be at the earliest stage possible, not the pooling stage. By the time MDS files a pooling application, it will have sent AFE and election letters for this acreage. Working interest owners are then put in a position of whether they're going to consent or not to participating, or risk non-consent penalties and losing, value of their leasehold interest. MDS should not be able to stronghold working interest owners into consenting to obtain the 45%, recognizing the statute says ownership and consenting equals 45%. And second, you're really devaluing the market for competition for the unleased mineral owners. At this time, Incline has been offering $4,000 per acre, while MDS is averaging $350 to $500 per acre. If the unit is approved, no unleased mineral owner will continue to receive the competitive offers from Incline and other working interest owners, given MDS's track record. They think it's an intentional strategic plan to devalue the unleased owners and the leases available. MDS has only 2 OGDPs approved, with no wells drilled in a unit to the south, and only 3 wells in a second OGDP approved that has been approved for 4 or 5 years, I believe. Overall, this order sets a precedent that any lessee can file an OGDP and spacing application with a single lease, if that is the only requirement for proving ownership at the OGDP stage, as against the current practice of the commission and I think the spirit of the 45% threshold. We'd also note that during the permitting review of the spacing application, staff considers the 45% threshold as part of its recommendation to approve, which we believe makes it an issue. We think that Incline, including joining parties, have a valid petition as an affected party, and it shouldn't be dismissed because it could present this opportunity at the pooling application. Alternatively, if this is approved today and that it's your position that Incline needs to wait until the pooling application, we'd ask a condition of approval that consent to an election does not equal consenting for the 45% threshold, and 2, that the OGDP will be undone if MDS does not achieve the 45% threshold when and if Incline and others petition. Thank you, and if I have any time left, I'll reserve it.
All right, thank you, Mr. Burke. Ms. Jost?
Thank you, Chair. Good morning, Commissioners, staff, council, members of the public. My name is Jamie Jost, and along with Kelsey Wozzelinki, we represent MDS Energy Development, LLC, in the Castor 29 Oil and Gas Development Plan application before you in this docket. Thank you for allowing MDS to provide a statement on Incline's petition and the hearing officer's proper dismissal of the petition that is solely based on an improper request to have the commission mandate that MDS comply with the 45% pooling threshold under the Act at the time that the ECMC is reviewing an oil and gas development plan and drilling and spacing unit application at this stage in the permitting process. MDS will also assume that each commissioner has reviewed the briefings on Incline's objection to the hearing officer's properly entered order dismissing the petition. So I'm going to keep this simple and to the point. First, as the hearing officer correctly stated in its order, the 45% pooling threshold does not apply to an OGDP or DSU application under 3460-116A or B of the Act, or ECMC Rules 303 and 305, which is what the OGDP and the drilling and spacing unit application are filed and you are to hear today. Even if all of Incline's allegations were taken as true in its petition, Incline cannot obtain its requested relief in an OGDP DSU application scenario. This is under the law. This is under 3460-116A and B that applies to drilling and spacing units and the ECMC Rule 303 and 305. There is no pooling application before you today. There's nothing in front of you under 3460-116.6 or Rule 306 that's sought by MDS in its OGDP and DSU application. Notwithstanding several misstatements by Incline's attorney, as he just stated, there are several factual inaccuracies that were provided. And also notwithstanding the fact that an OGDP and DSU do not require the percentage threshold, MDS does hold 45.6% interest and consent in the Castor unit. And that meets the future 45% pooling threshold requirement if and when a pooling is sought on this DSU. Finally, any allowance of Incline's petition based on the 45% pooling threshold to be applied at this stage in the permitting process in the OGDP and DSU stage would be contrary to law and commission's rule. This commission hearing officers have been consistent in recognizing that the 45% threshold is not applicable in DSU and OGDP application situations in recent orders. The commission should uphold the hearing officer's proper order dismissing Incline and should allow MDS to proceed to an uncontested hearing on the Castor 29 OGDP application today. Thank you.
Any last word, Mr. Burke?
Yeah, a quick last word. Ms. Joe said that the MDS has 45.6% working interest. We think that's a factual issue we were hoping to, bring to the commission. That has not been proven. And then two, the statute, the pooling statute 3460-116 does in the 45% describe pooling. I understand that this commission has two different practices, one for forced pooling and one for the OGDP stage. But when you're creating a unit, you're pooling multiple tracks together to create a unit and different leasehold and ownership interests. So we think Incline's an effective party and the petition is proper. Thank you.
All right, thank you very much. Before we move to deliberations, does any commissioner have questions of counsel of record? Commissioner Oath?
Thanks, Mr. Chair. Ms. Jost, I apologize if I missed this in your response. Did you have a response to the sort of alternative proposed by Mr. Burke in the event that the commission were to move forward about a suggested COA?
Thank you, Commissioner Oath. This is the first we've heard of it. I mean, MDS will abide by the commission's rules that when a pooling application is filed for the Castor 29 OGDP, that Incline would be an affected person and would have the right at that time to petition. But that timing is not now. There will be no agreement that they have the ability to undo an OGDP when we have a speculative piece of pooling at this point in time. So again, MDS will follow your rules like we have. But I don't think there needs to be an agreement to an unnecessary COA on a speculative pooling at this point in time. Thank you for asking.
Thanks.
Other questions of counsel? All right, seeing none, I'll start deliberation with some thoughts singular to myself as one commissioner. The commission, I believe we've now considered Incline's appeal of the hearing officer's order dismissing Incline's petitions. Incline's appeal and underlying petition are based on the argument that MDS allegedly cannot meet the 45% mineral threshold requirement. However, that requirement is not applicable at the OGDP and DSU stage. 34, 60, 116, 1 through 5, and Rule 305 address the creation of DSUs, and neither set a voluntary participation threshold. 34, 60, 116, 6, and Rule 506 address pooling. That is where we find the 45% threshold. Today, we're considering an OGDP and a DSU application. It's not a pooling application. That's next, assuming we get through the OGDP and DSU. Therefore, in my mind, the 45% threshold does not apply at this point. I also do not believe we need to address the two COAs from Mr. Burke. The applicant will have to address all applicable rules at the pooling stage, and that's protective, and there'll be an opportunity to be involved at that point. With all that said and done, I am comfortable moving to decline Incline's appeal, to uphold the hearing officer's order dismissing Incline, and moving forward with MDS's Castor 29 OGDP application. I'm happy to make that motion, but I also want to hear from my fellow commissioners. So there's no motion yet. Anybody else? Commissioner Messner?
Thanks, Mr. Chair. I agree with your conclusion. I would also note that it is a requirement that an applicant get 45% in order to be able to be issued Form 2s. And so no drilling operations can happen until they are able to achieve that 45%. But that's not at this stage. And so I would agree with you in that respect that at this time, that's not a requirement for this review.
Others with deliberative thoughts? All right, then I would move, as indicated in my deliberative thoughts, that we decline the appeal, we uphold the hearing officer's order dismissing Incline, and that we move forward with MDS's Castor 29 OGDP application. Do we have a second?
Second.
Motion and a second. Further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? All right, motion carries. I believe we'll probably be seeing you at the pooling stage, Mr. Burke. Thank you for participating.
Thank you.
All right, Ms. Jost, we now will take up the case in chief on this matter, and I believe we get one last chance to hear from Mr. Kavanaugh.
Well, thank you again. It's the final time you hopefully see me today. Thanks again for this opportunity, and thank you for everyone online today, and for allowing me the few minutes regarding Weld County's WOGLA process for the MDS Energy, Oil, and Gas Development Plan. Today we're going to be talking about the Castor 29, which on September 27th, 2023, Weld County held a pre-application meeting for, which is the location before you today. Attendees included the MDS Energy staff, Weld County staff, ECMC, and the CPW. The 1041 WOGLA application was received on January 8th, 2024. Weld County did not receive any public comments or applications for intervention for this location. The 1041 WOGLA hearing for the Castor 29 was held on June 13th, 2024, and approved by the Weld County hearing officer. The final order was recorded within Weld County Clerk and Recorder and published in the Greeley Tribune on June 28th, 2024, which creates a vested property right. Due to the fact that MDS Energy has completed the 1041 WOGLA application process, that a final order has been issued, recorded, and legally published, Weld County has no additional concerns with the pending ECMC permit, and Weld County agrees with the director's recommendation and supports approval of the permit. Thank you for your guys' time.
Thanks again, Mr. Kavanaugh. Again, as always, we appreciate the perspective of Weld County and their permitting process. it goes into the consideration of the work we do here. Does
Thank
anyone
you.
have questions? Seeing none, we'll let you go. Thanks again for being with us. Ms. Jost, if you want to elevate your witnesses, we'll get into the swearing in of witnesses per piece of the stage.
Great, thank you, Chair. We have several witnesses, so if everyone could please come on screen. We do have one that is overseas, and so since we're running a little bit early, if he joins us, we can have him sworn in later during the subject matter panel. He will not be speaking today unless there's a commissioner question. So Mr. Boudreau, we have everyone on screen. Mr. Dunn, can you please come on video? Great, thank you.
Thank you, Ms. Jost. I'll ask each of you to raise your hand and state your name and then swear to tell the truth. I'll start with Justin Dunn.
Justin Dunn.
And do you swear to tell the truth?
I swear to tell the truth.
Thank you. Richard Sade.
This is Richard Sade. I swear to tell the truth.
Thank you. Jim Jacobson.
I'm Jim Jacobson. I swear to tell the truth.
Andrea Gross.
My name is Andrea Gross, and I swear to tell the truth.
Neil Duncan.
For some reason, I was muted. Neil Duncan. I swear to tell the truth.
Thank you. Did I get everyone, Ms. Jost? You're muted, Ms. Jost.
Sorry about that. Yes, we do have one more, Mr. Wakut Kandaki. If he does join, we can swear him in before the subject matter expert panel if we need to.
Thank you.
Great, thank you so much. All right, Chair, if you are okay, I can have everyone go off screen except for Mr. Rich Sade and Andrea Gross. And if it's okay with you, I'm happy to start.
Go ahead. Thanks.
Okay, wonderful. Well, again, good morning, Chair, Commissioners, staff, and members of the public. My name is Jamie Jost, and along with my partner, Kelsey Wesselinki, we represent MDS Energy Development LLC and this Castor 29 Oil and Gas Development Plan and docket number 2411-00288. Thank you for the opportunity to allow us to present to you this morning. Before we dive into the substantive portion of MDS's OGDP presentation, I'd like to introduce Mr. Richard Sade of MDS Energy Development and ask him to provide an update on MDS Energy Development's development and production in Colorado to this commission. This is MDS's second OGDP in the state of Colorado, but the company has drilled and operated wells in the state of Colorado for several years. Mr. Sade, I'd like to go ahead and turn it over to you for a few comments.
Good morning, commissioners. I'd like to start by saying that we at MDS appreciate the guidance and expertise from the staff and from the commission on our first OGDP application last fall. We took those learnings and we applied them to this Castor 29 OGDP application before you today. As an update, MDS has successfully sponsored now 21 oil and natural gas drilling partnerships. We've raised over $1 billion of outside investor capital. MDS is committed to responsible energy development in Colorado, and we look forward to investing certain of that capital in the DJ Basin. Since our first set of hearings with the commission, we've continued to make progress in our Colorado developments. In Colorado now, we've constructed 3 well pads. We've drilled and completed 4 horizontal wells, which have produced 400,000 barrels of oil. And we've begun drilling on another 6 horizontal wells. We recognize that the permitting process is lengthy and complex and not without obstacles. However, we appreciate the work that the commission and the staff put into analyzing and evaluating approvable projects like this Castor 29 OGDP today. Thanks for taking the time to hear me out this morning, and I'll hand it back to Ms. Jost.
Wonderful. Thank you, Mr. Sade. The MDS Energy Castor 29 Oil and Gas Development Plan requests approval of a 1,289.9 acre oil and gas development plan and corresponding 1,280 acre drilling and spacing unit to allow up to 7 new horizontal wells to be developed from 1 new oil and gas location just outside the OGDP boundary. Here you can see the application lands include sections 21 and 22, Township 8 North, Range 59 West. The proposed surface location will have approximately 9.9 acres of surface disturbance. The surface location is not within 2,000 feet of a residential building unit, school facility, high occupancy building unit, or childcare center. It's not in a disproportionately impacted community, and it's not in high priority habitat. The Castor 29 OGDP application has been progressing through the ECMC hearing system for 6 months. On January 8th, 2024, the WOGLA permit was submitted to Weld County and was approved on June 13th, 2024. On November 20th, the original OGDP application was filed with this commission, and on January 7th, ECMC issued the completeness review spreadsheet, and we amended the Form 2A and the 2A and the plans were then filed with the ECMC on the same day. On January 14th, the Form 2C completeness was approved. Notice was sent out, and we did receive one petition on February 17th from Incline, which is now dismissed, but no public comments on the Form 2A or the hearing documents. On April 16th, the director's recommendation was issued that recommended approval, and here we are in front of you today. The Castor 29 OGDP application has met the requirements and the criteria for an approvable OGDP and Form 2 permit. As you can see, MDS Energy submitted each of the required Rule 303, 304, and 305 documents, and each submission was confirmed by the director's Form 2C certificate of completeness. Next slide, please. The Castor 29 OGDP does not meet any of the Rule 304(b)(2) alternative location analysis criteria and has an EnviroScreen score of 26.7, one of the lower scores this commission has seen. As you can see from these location photos, the Castor 29 oil and gas location is in an extremely remote area of the DJ Basin, away from human and wildlife receptors. With that, I'd like to go ahead and turn the presentation over to Ms. Andrea Gross from Upstream Petroleum Management to continue with our slides.
Thank you, Ms. Jost. And good morning, commissioners. As Ms. Jost just said, my name is Andrea Gross, and I'm the president and owner of Upstream Petroleum Management. We have been assisting MDS Energy with their local and state permitting of this OGDP before you. On this slide, this is the intended phases of operation and their schedule. MDS wishes to construct in October of 2025 and will begin drilling in Q1 of 2026. They will complete the wells and put them into production in April 2026. Please note that MDS will conduct pre-production activities outside of the ozone season. MDS began consultations with Weld County with a pre-application consultation on September 27th of 2023. In attendance was MDS, myself, Weld County and ECMC staff, and Colorado Parks and Wildlife. No parties at that consultation identified any issues that would prohibit us with moving forward with the proposed location. The WOGLA was approved at the hearing on June 13th, 2024 and recorded on June 26th, 2024. The WOGLA approval is a vested right under Weld County Code in Colorado. MDS participated in several consultations with different agencies throughout the local and state process. Yes.
Probably what we're gonna.
Is there a problem?
Chair, sorry, Chair.
Can I continue?
Yes, please, Ms. Gross.
Okay, sorry about that, and thank you. Next, MDS consulted with CDPHE on February 10th, 2025, which has its own slides regarding those BMPs. There was no formal consultation with CPW because it's not within any high priority habitat, but MDS did participate in a courtesy onsite on November 16th of 2023. WOGLA notices were sent to all surface owners within 2,000 feet of the proposed disturbance, CPW, BLM, and the first responders on November 9th, 2023. No protests or public comments were received prior to the WOGLA hearing. No community meeting was required by ECMC, and no public comments were received for the Form 2A or hearing application. I would like to highlight a couple of very important details of this OGDP. One to note is on the, could you go back one, Kelsey? Thank you. At the time of our CDPHE consultation, MDS was not able to commit to a Tier 4 or equivalent rig. However, since that consultation, MDS and their consultants continued to have discussions with rig companies, and they are now able to commit to a Tier 4 or equivalent rig. And I'd like to note that a revised 2B was submitted through email to ECMC staff. So it should be reflective that those emissions are inclusive of a Tier 4 or equivalent rig. In addition, MDS is committed to pipeline takeaway of all produced fluids, as well as natural gas. However, they will have 2 permanent oil tanks and 5 permanent produced water tanks for maintenance and in the event that the pipeline goes down. They will use Group 3 drilling mud for drilling operations. Fresh water will be trucked to the location for drilling operations, which will reduce truck traffic, as well as fresh water will be piped to and stored on location in an MLVT, which also is a truck traffic reduction measure. Next slide. Thank you. As discussed, MDS consulted with CDPHE. At the time, they committed to 27 BMPs. I won't read all of them to you as you're very familiar with them, but I will highlight just a couple on each of the pages. MDS will maintain all of their vehicles and equipment, and MDS intends to electrify or use renewable power for their production equipment. MDS will cover trucks transporting drill cuttings, and they will use a LACT system, which reduces and removes truck traffic from the road. MDS is committed to the high ozone BMPs, as well as that they will maintain a publicly accessible digital information source with information about this application, including a primary contact method to address complaints and concerns. Again, MDS will use an MLVT. They will not use any PFAS compounds. And I'd like to note that Weld County fire districts have already moved away from PFAS. However, if PFAS containing foam is used at a location, the operator will properly capture and dispose of that. The next slides are going to detail BMPs that were submitted within the site-specific mitigation plans. As discussed, one of the biggest mitigation measures that MDS used was avoidance. They were able to site this location outside of any high priority habitat. In addition to that, the operator will establish company guidelines to minimize wildlife mortality from vehicle collisions, as well as all tanks and above ground facilities shall be equipped with structures or devices that discourage nesting of raptors and corvids. MDS has an approved preliminary drainage report with Weld County, which included many stormwater management BMPs. Within the stormwater management plan that was submitted with the 2A, I'm going to highlight just a couple of the BMPs, but please note that this is not all of them. Diversion ditches will be constructed around the entire well pad. It will be utilized around the perimeter to control run on and run off, as well as to control sediment and interim stabilization. Earthen berms will be constructed also around the entire well pad, as well as culverts will be installed along the county road as directed by Weld County. The next couple slides will detail some of the BMPs used within the waste management plan and leak detection plan. MDS will transport waste to only permitted locations. They will conduct site inspections throughout all phases of operations to ensure that that waste is properly stored and emptied, and all transport will be conducted via compatible containers and by licensed transporters. Within their leak detection plan, they are committed to above ground flow lines will be visually inspected on a weekly basis and tested triennially. Underground lines will be pressure tested every 3 years. Pressure testing records will be maintained by the operator of a minimum of 10 years. PVT alarms, automation, and other sensory monitoring devices will be used to monitor active tank levels at all times. As discussed, there's very specific site BMPs throughout all phases of operations. I will highlight just a couple. During drilling, continuous monitoring will be used to track fluid volumes and monitor for leaks. During the completions operations, temporary produced water storage tanks will be placed on general secondary containment, and the berms will enclose an area sufficient to provide secondary containment for 150% of the volume of the largest single tank. During production, secondary containment devices will be constructed around crude oil, condensate, and produced water. Within their dust mitigation plan, MDS is committed to graveling all working surfaces and performing interim reclamation within 6 months of the well. Application of fresh water will be used during the dry season, as well as mag chloride when needed, and regular road maintenance such as grading and adding additional gravel will be done on an as-needed basis. During construction, MDS will take care to not have blight leave the location. As Ms. Jost discussed, this location is not within any HPH and it is well over a mile from any RBU. However, MDS did do a photometric study and they are committed to light mitigation. Emissions best management practices were discussed pretty heavily in the CDPHE consultation, but I'd like to reiterate that they won't conduct pre-production activities during the ozone season. They will use Group 3 drilling mud. Production equipment will be electrified, and they are now committed to a Tier 4 or equivalent drilling rig. Within the interim reclamation plan that was submitted, there are a couple of BMPs that I'd like to highlight, and as well as a detail of the construction of the pad will be approximately 9.9 acres, but it will be reduced to just about 2.8 acres after interim reclamation. Gravel will be installed on the well pad and access road. Continuing with interim reclamation, initial seedbed preparation will consist of backfilling, leveling, and ripping all compacted areas. And final seedbed preparation will consist of contour cultivating to a depth of 4 to 6 inches within 24 hours prior to seeding. A certified weed-free seed mix will be used, and that seed mix will be used on all disturbed surfaces. Annual or noxious weeds shall be controlled on all disturbed areas. As directed by the private surface owner, an intensive weed monitoring program will be implemented. With that, I'd like to turn it back over to Ms. Jost.
Wonderful. Thank you, Ms. Gross. Commissioners, along with the requested relief to approve the Castor 29 OGDP application, MDS also requests approval of the corresponding drilling and spacing unit that was attached to the application as Exhibit C. MDS is seeking a 1,280-acre drilling and spacing unit for the Niobrara, Fort Hays, Sharon Spring, Codell, and Carlisle formations, and they plan to develop up to 7 new horizontal wells in the unit. MDS holds approximately 45.6% interest and consent in this DSU and is continuously leasing the remaining open acreage in this unit. Next slide, please. The director's recommendation issued on April 16, 2025 provided a thorough analysis of the ECMC staff and director's review of the Castor 29 OGDP and recommended approval. We've reached the end of our presentation today and are grateful for your consideration of this application. We'd like to thank Weld County for its comments today as well. The Castor OGDP application is an approvable application, is in compliance with your rules. No public comments were filed, and the one petition regarding the pooling threshold interest has now been appropriately dismissed. MDS holds a WOGLA permit for the location, and this location provides protections of public health, safety, welfare, environment, and wildlife resources, and protections of adverse impacts to air, water, soil, and biological resources. So to conclude, MDS Energy is requesting that this commission approve the Castor 29 OGDP application. Provide that the 7 horizontal wells will be located on the Castor 29 oil and gas location unless the director grants an exception. And approve the associated Form 2A for the Castor 29 oil and gas location. We request that you find that the OGDP will protect and minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. And also request that the approval of the 1,280-acre drilling and spacing unit application be within that approval request today. This wraps up our presentation. We do have a panel of subject matter experts who will now join us. If I could ask everyone to come on panel. And Mr. Thomas, we do have Mr. Kondaki available if he's able to be elevated at this point in time.
All right, as we're working on elevating that witness, we have other witnesses available for questions from the commission. Commissioner Messer?
Thanks. Appreciate the application. Lots of good BMPs that are associated with this, but I did have some questions, or a question around the produced water storage. I think there was a BMP that was committed to by CDPHE that indicates you will not store produced water on site, and that there will be produced water pipeline takeaway, but there's still 5 produced water tanks that are being proposed. And my understanding is that they're permanent produced water tanks. And so help me understand the need for 5 permanent produced water tanks with produced water takeaway and a commitment to not store produced water on site.
Thank you, Chair. Ms. Gross, do you want to take this?
Thank you, Commissioner Mesner. Those tanks, my understanding is they are there in the event that the pipeline, if there's an upset in the pipeline and they're going to need that storage for a temporary basis. So it will be permanent in the event of a temporary upset in the pipeline. They will need to have some sort of storage on location.
Okay. Understanding that, I will note that typically when we see applications like this with temporary produced water storage for upset conditions, it doesn't consist of 5 permanent tanks. And so to me, that seems a little bit overkill, understanding that there may need to be a need for that. And the only reason that I bring this up is the tanks have been identified as one of the primary sources of emissions. And so there's been a consistent attempt to try to reduce the number of tanks on site to whatever's absolutely necessary. And so that's why I'm asking about this.
I believe that FDS, they did calculations. They have consultants that looked at the water volumes usually produced within the DSU, and they believe that that is the number that would be necessary to have on site if the pipeline went down. And I'm sure they're willing to look at those and for future obligations or future OGDPs.
Yes, I was hoping to just add to Andrea's comments, if I may.
Go ahead.
The design is for a 24-hour upset, and those tanks would be emptied otherwise. The only time that they'd ever have water in them is if the pipeline was to go down. And then once the pipeline would be back up and running, those tanks would be emptied into the pipeline. In the event that the pipeline is down for greater than 24 hours, then the facility would be shut in.
Further questions for the panel? Seeing no further questions, did someone desire to deliberate? Anybody care to make a motion? Commissioner Oath?
Sure. Thanks, Mr. Chair. I would move for approval of this OGDP application. I don't believe there's any COAs involved.
I'm comfortable seconding that motion. Motion and a second. Is there further discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye. Aye.
Any opposed? that motion also carries. Thank you, Ms. Jost, for the application and the presentation. Thanks to our staff for the work getting it to the place that it is in now.
Great. Thank you,
With
Chair and
that,
Commissioners.
I believe we can adjourn. I would move to adjourn.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
All right. Good work. See everybody next week. Have a good week.